Hi everyone, thanks for joining. Really great to see you, Nick. How are you doing?
Nice to see you as well.
Yeah, so really excited to get it going. So many people on this masterclass today. And as you know, TCPA is just so important for all businesses alike. So let's get this going. Nick, could you tell us a little bit more about your background? Everyone's so excited because you have a lot of experience in the TCPA
Yeah.
area.
So we're a small kind of boutique firm based just out of Columbus, and it was founded by a former Ohio Attorney General and Assistant Attorneys General. So we focus exclusively on kind of consumer protection, privacy type of laws with a particular focus on TCPA on the business side, right? So we're representing businesses, helping them stay out of trouble, helping them comply with a bunch of different federal and state laws, and hopefully avoiding any type of class action lawsuits or attorney general investigations or things like that.
And what got you into TCPA specifically?
Yeah, well, one of the founding partners was actually in the Ohio AG's office when all the do not call laws got passed. And so she was very familiar with TCPA and all the telemarketing type of laws. So when she went into private practice, she just kind of naturally picked up there, and I ended up joining her team. And I've been in TCPA since 2008. So it's been an interesting transition, not something that you necessarily think you're going to specialize in when you're in law school, but it's been good. And it's an important issue with a lot of, a lot of things that you have to manage. So it's been good.
Yeah, I think it's so important because more people are becoming hesitant to answer phone calls from random numbers, and
Right.
businesses need a different way to reach out, but they gotta stay compliant.
Yep, absolutely. We'll hopefully help some people figure out how to do that here today.
All right, let's get it started. Okay, I'll introduce myself. I'm Jess Lee. I'm the CEO of Bite Size. Who here has heard of Bite Size before this masterclass? So, just for people who haven't heard of Bite Size, we help with text message communication to your leads and prospects. And it's a new way to follow up to leads that are hard to reach otherwise. We integrate with all of the CRMs, and we act on top of your CRM. We have a gift at the end of this masterclass for folks, and we'll do a raffle for an Amazon gift card.
I'm happy to just dive in here since we have a limited amount of time today, and there's a decent amount of content just because it's such an important issue. Actually, the disclaimers are all important. This is not legal advice. It's not establishing attorney-client relationship. It's just provided for informational purposes. So you should make sure that you talk with your attorneys before doing anything. It wouldn't be a presentation from a lawyer if it didn't have some type of disclaimer. So I wanted really just to start with the TCPA basics. I think some people probably are aware of these things. Maybe some of you, TCPA is new. And so just real high level, it's a federal law. It governs calls, it governs text messages, marketing faxes, and it has specific rules for pre-recorded messaging and for calls and texts to cell phones. And so largely what we're going to talk about today is that rule around calls and texts to cell phones. But one thing to not lose sight of are the do not call. So in addition to complying with the cell phone rules, you have another layer of compliance that's necessary. It's the do not call laws. We'll talk about those. One of the things I think people were surprised to know is that some of these rules, not all, but some of them apply to business communications and also non-marketing communications. So you have to be cognizant of any type of outreach that you're doing, any type of text campaign that you're running to make sure, even if it's a non-marketing campaign, that you're complying with the TCPA. Real quickly, in terms of enforcement, the federal agency responsible for that is the Federal Communications Commission, or the FCC. They do some enforcement, but it's really sporadic. It's really truly the bad actors, the people that are blasting millions and millions of pre-recorded messages, spoofing caller ID, that type of thing. Really what we're worried about mostly is the private right of action. So if you receive a text message or call and it's an unlawful call, you can sue. There is statutory damages. So this is probably what a lot of you have heard about. This is probably why you're a little bit hesitant to text, or you just want to make sure that you do it the right way. And what I always tell people is it can be scary. Don't ignore it, but don't necessarily use that as an excuse not to do it. It's more about doing it the right way. So making sure you have good policies and procedures in place, and make sure you're knowledgeable about the law and you've got good protocols to make sure that you comply. It's actually the third most common lawsuit filed in federal court today, behind the Fair Debt Collection Practices Act and the uh, Fair Credit Reporting Act. So it is pretty prominent. We saw a spike in about 2018, 19. It's gone down a little bit, but it's still several thousand of these types of lawsuits filed each year. So again, not trying to scare anybody, just making sure that you understand that you need to do it the right way. So in terms of actual substantive rules, the first thing I wanted to talk about is the rule around calling and texting. And so the general rule is, if you're using certain types of technologies to call or text a cell phone, that's a pre-recorded message or an automatic telephone dialing system. Everybody calls it auto dialer, or ATDS for short. You have to have consent. And the type of consent that you need depends on the type of message. So if you're sending a marketing or an advertising message, you have to have written consent. And if it's a non-marketing message, you have to have express consent. So there's a lot to unpack there. I could probably do a 1-hour presentation on what is an ATDS, but we're actually going to break that down here a little bit later into very simplistic terms. And we're also going to talk a little bit about what constitutes consent. But just understand that this is the framework that we're dealing with. These are the kind of threshold issues that we have to work through. And as I mentioned, some rules apply to B2B and B2C communications. This is an example. These cell phone rules do apply if you're contacting businesses. I think most people are generally using this in the B2C space, but it does carry over for those that may play in the B2B space as well. So beyond that, I mentioned earlier that there's also do not call laws. And the general rule here is that, at least at the federal level, right, you can't call or text the number that's on the national do not call registry without a valid exemption. And so the two exemptions are if you've got written consent to call or text that person, or if you have an established business relationship with them. That term has kind of two prongs to it. So this could be somebody that has previously made a purchase from you within the last 18 months, or it could also be somebody that's inquired about your products or services. So maybe they filled out a form, but that form doesn't quite go so far as to give you written consent, but they've inquired about what you're offering. That gives you 3 months that you can call or text them. These are the federal rules. There's different state rules. We'll talk about that in a little bit later. All of those exemptions, though, are overridden by a seller company specific opt-out. So if somebody says, don't call me, don't text me, specific to your company, that overrides any prior exemption. So if you had written consent, but they later tell you they don't want to be contacted anymore, you need to make sure that you honor that. Same thing if you're relying on that EBR exemption and they tell you that they no longer want to receive communication. So managing opt-outs is going to be very important, as you'll see. So with that, just very high level on the two substantive rules, I thought one of the best ways to kind of do this is to go through kind of a bunch of myths. So things that people often think about TCPA or this area of law in general, and then we can kind of go through and dispel those myths a little bit. So the first one is that the TCPA is the only law that applies. A few different things that we're going to want to worry about. You're going to certainly want to worry about the TCPA. If you actually go back, I'm not quite done with this slide yet. You're going to worry about the TCPA, of course, but you also got this federal law, the telemarketing sales rule, that a different federal agency enforces. It's only applicable to marketing communications. So if you're doing informational type of communications, the TSR does not apply. But for marketing communications, there's those two different federal laws, and then there are state-specific laws. So if you're texting, there are a handful of states. California is one of the most notable. Washington actually has some pretty onerous restrictions, but there are state-specific texting rules. And then states also have their own DNC laws. So you have to make sure that you're checking all the boxes when you're doing this. It sounds daunting. It can be. With a little bit of guidance and just some protocols in place, though, I think it becomes much easier. So just make sure that you are checking all of those boxes when you're going through your text programs. The second myth is that all texts require written consent. And again, I mentioned earlier that the federal rules, the TCPA rules, kick in if you're using an auto dialer or an ATDS. That is a very critical issue. And courts are kind of in two camps on what qualifies as an ATDS. In one camp, if you're dialing or texting from a list and there's automation involved, you're doing a kind of a blast texting program, something like that, you have to have written consent because they deem that to be an ATDS. In the other camp, it's much narrower. They interpret this as just something that actually randomly and sequentially generates the phone numbers themselves and then text those. So it's something that would just send it out to every phone number in the universe, through random number generation or by just changing the number by like one digit each time. The problem, right, is that because there's that court split, you really have to default to the more conservative position. And so you really have to say, if I'm doing blast texting, if I'm doing batch texting, auto response texting is a little bit of a gray area, but a lot of these texting functionalities will trigger the auto dialer restrictions, and that's where the written consent comes in. So just know, when you want to just blast it out, you need written consent. If you're using a purely manual system, that every text has to be initiated through some type of human intervention, so some type of a click for each and every text, even the broad interpretation would exclude that. So what that means is you're not subject to any of those TCPA consent requirements. You may have to check states, you still have to comply with the DNC rules, but just the TCPA's like auto dial restrictions, which is where most of the litigation, I mean, that's where all the class action litigation is right now. Those go away. We don't need to worry about that if we're not using an ATDS. So very critical. Like I said, I could probably do an hour on what is an ATDS and all of the different issues there, but that is just one thing that you need to look into. One thing that you need to think about is, if I don't have consent, I need to use a purely manual platform. Okay, so myth 3 is that the TCP actually prohibits all mass texting. So I said, if you don't have consent, right, you want to go down that path of manual texting. But if you do have valid consent, you actually can use a more robust platform. You can do batch texting. You can do all of these things. But the key is you have to make sure that you're meeting very specific written consent requirements. So one of the common issues that we see is people just buying leads, but those leads just have no consent language, or they don't authorize that specific company or that specific seller to call or text them. It's too generic. It's not specific enough. So you need to make sure that you have consent that's specific to your organization. You need to make sure that it's authorizing marketing communications, not just some type of outreach. You have to get their signature or electronic signature. Typically, we see that through like an online form. You'll have to like check a box or click a button that says, by clicking this, you're providing consent, and that's got all the disclosures that are necessary. So there are ways to do that in a more streamlined fashion than truly having somebody sign a paper form or pull up DocuSign and sign it that way. You can be a little bit more relaxed on what you do to get a written signature, but to get an electronic signature, but it is important to set it up the right way. And last is these clear and conspicuous disclosures. People will try to bury them in a terms and conditions. That's not going to work. They'll try to put them below the button they're using to get consent in really tiny font that you need a magnifying glass to read. That's not going to work either. So make sure that if you're using leads, whether they're your own lead forms, you're buying leads, that's fine. But if you're using that to rely as written consent, it needs to meet very specific criteria. If it doesn't, maybe it's enough to create that inquiry EBR, right? So maybe you can still reach out to these people, but you might have to use a manual system instead. So really critical to analyze these lead forms and make sure that you either have written consent or potentially an inquiry EBR, which would cover do not call laws, but it would not cover using an auto dialer. The last thing I want to mention on this slide is the documentation of consent. If you get sued, it's your burden to prove consent. So make sure that you have a good system in place to save the consent records, and you'll want to save those for the duration that you can be sued. So it's really, as long as you're texting that person, plus another 5 years past that you want to document that you had consent to do that. Okay, so myth number 4 is a lot of companies think, well, I'm not actually doing any type of marketing text. I don't do telemarketing. But then when you drill down, that may not be true. So number 1, they say, I don't make any sales, right? I'm just setting up an appointment. That's still deemed to be marketing because it's supposed to design in some type of future sale. I think the other area we see people struggle is they start with what they think is like an informational type of text. It's customer service communication. Maybe it's a recall notice. Maybe it's something like that. But then they add some type of marketing spin to it. So it's a dual purpose text. If it's dual purpose, they treat it as marketing. So you need to be very careful about the scope of what you're texting about and what you're saying. Service reminders, right? So people that are reminding people that their vehicles due for service or something similar to that, that is generally going to be a marketing communication unless they're covered under some type of maintenance plan that they already paid for. But if you're trying to get them to come in for new repairs that have not yet been paid for, that's going to be deemed a marketing communication. It's not just the sale of a vehicle or the sale of some other type of product or service. The other thing I get asked is, well, if I text somebody and ask for consent, is that allowed? And there actually is one TCPA case, one opinion out there that said that that type of request is not itself a marketing text. But I'm a little bit nervous to rely upon that one opinion. Courts reach different conclusions all the time on certain issues, and that's an issue where I think some courts would view it to be marketing. So I would just caution you, right? If you're going to do that type of thing, you want to make sure you're complying with do not call laws, and you'll want to probably use a manual system to do that, because if you're using an auto dialing system, that initial text and you don't have written consent may be a violation. So be very careful on that. I think this bullet at the bottom cannot be underscored enough. You have to look beyond just the language in the text to determine whether it's marketing. They will look at the purpose. Why did they send that? What downstream activity did they think that that would generate? And so oftentimes people will keep the text very generic, like, hey, we need to talk to you, or we're having this great event, come in for a free, coffee or pizza or whatever it might be. But then at that event, there's some type of sales activity going on, and that turns that initial text into a telemarketing or an advertising text. So just be very careful about the purpose of the text, not just the content of it. Number 5, in terms of the miss, is that people often think that the TCPA requires a double opt-in. That's actually not true. What you need is written consent. Under some legacy industry standards, the Mobile Marketing Association standards that aren't really the applicable industry standards anymore, they required a double opt-in in certain situations, not all, but in certain situations they required it. That's not the case anymore. So it's not even required under industry best practices. It's not required by the TCPA. I will tell you that it can be helpful in certain situations. So you want to make sure that if somebody filled out an online form that they didn't mistype the number, or it's been a while since you talked to that person and you want to make sure that they still have that phone number, requiring them to double opt-in before you keep communicating with them can be a good idea. It can be a successful risk mitigation strategy. It's just not legally required in all contexts, or really any context. So just know that I'm not saying you shouldn't do it. I'm not saying you should do it. It's really fact specific and something that you may want to look at, but it is not a legal requirement. Number 6 is there's something out there called the CTIA standards. These are kind of the industry standards, or kind of best practices in the industry. And oftentimes people think that those are enforced in the same way that the TCPA is, and that's just not true. So TCPA is a law. It is a statute. It's governed by the Federal Communications Commission. You have all those lawsuits that I mentioned earlier, and that's where the primary risk is. The CTIA rules are good best practices, and wherever possible, I would certainly recommend following them, but they're not laws. And so, number 1, you can kind of pick and choose, how strictly you want to follow them. In the event of an issue, what you're talking about is maybe your text, if you have too many texts and you're not following these rules, they may just start blocking your text, right? That's often a volume issue. If there's some type of non-compliance, a carrier may look into it a little bit more, and they may, cut your texting off, that type of thing. Again, that's almost always driven by blast texting. You're just doing too much. You're sending too many texts to people that you have no relationships with. You're just using it kind of with very little rules in place. And those are the types of things that get companies in trouble. So again, not telling you not to comply with CTIA. There are best practices. I always encourage my clients to comply wherever they can, but there is some leeway there if you're not meeting every single requirement, and it doesn't involve that private right of action risk that we're talking about. Is probably some type of a blocking issue that you could run into if you're egregious about it. So the tips, which is on the last slide, I think you'll probably understood what many of these are. You really need to analyze your platform, whether it's an ATDS, because that's going to determine which rules apply. Is it just do not call, or is it do not call and written consent? You need to consider the functionality of that system. So not just how you're using it. It's counterintuitive, but if you manually text from a platform that has auto texting functionality, you can run into issues. So you really, really need to vet the platforms that you're using. I mentioned the documentation of consent. I mentioned the scrutinizing of lead forms. And I think the other thing maybe to point out here is you need to follow the do not call laws. So this slide really just kind of sums up all the things that we've talked about. It's a good kind of checklist for you to consider, but you need to make sure you're following those state rules as well, and you need to make sure that you're honoring opt-out. So with that, I know there's a lot of content. I'm sure there are questions. Jess, if you want to fire those at me, I'm happy to answer them.
Yeah, thank you so much, Nick. That was really speedy, but also just full of good meat there. So thank you so much.
I think you had a
So
question.
one clarification, yeah. So one clarification for the bite-sized customers here.
Okay.
They use a manual texting platform, but they call their campaigns blasts. Now, if you're doing blasts, using the manual texting platform,
Got
what
it.
does, that's, can you clarify what that means?
Yeah, I mean, the term blast texting is not in the TCPA. That is not a legal term. It has no legal significance. It's just an easy way to explain the process of I have thousands or sometimes tens of thousands or even millions of numbers I want to send a text to. I load them all up, I type the message, and then I hit one button and it just sends that message. There may be some like name personalization, but generally it's one process, one scheduled batch, and then they all go out. That's what I think of when I say blast texting. If you're using a manual platform, so I am obviously familiar with Bite Size, you can set it up so that here's everybody I would want to receive a text, but it requires a person to press every one of those, press a button to send each and every one of those texts. That would fall into the manual type of texting that we're talking about. So you can call it blast, you can call it something else. That's not really the legal significance. It's really about, are you sending it to large batches at the same time? Or are you sending each text individually, requiring a different action from a person for each text?
Mm-hmm. Okay, yeah, that's really helpful. A lot of the bite-sized customers have our assistants clicking send for them once they schedule it. So, yeah. Here's a question from Edward. How do I ensure that my texting provider is a manual platform?
Yeah, it's a good thing. So I think number one, the first thing I would always ask is, have they thought about this, right? Have they consulted with legal counsel? Do they have an opinion letter? Have they given any thought to that? If the answer is no, it may end up being okay, but that's a red flag that maybe that there's something there. Second, to have they thought about the key issues? So as I mentioned before, it triggers on whether the system is capable of performing certain functions. If it is capable, it's going to be an ATDS even if you don't use them. It's crazy. I know it's like people look at me like I have three heads when I explain that to them. It's like saying that you're responsible for shooting somebody because you have a gun and it could shoot somebody. I mean, it's just an absurd legal standard, but it is what they apply. So you really need to dig into the functionality of the system. And then the other thing is, to the extent that there's any vendors out there that you're considering, you need to look at to what degree, if they have both a manual platform and a more like batch texting platform, have they segregated those? Because if they're just different modes on one larger system, that could be problematic, at least create some gray area. If they are completely separate systems and they use different hardware on the back end and have the different software installed on it, et cetera, then one system's functionality won't taint the other system's functionality. So those are the types of things that I always look at when it comes to texting platforms, and quite frankly, phone systems too. If you're calling somebody, I understand calling's dying a little bit, and that's why texting is so important. But a lot of companies do both, and if you're doing both, you would do the same type of analysis on your phone system as well.
Yeah, thank you. That's really great. And it's really important, even at Bite Size, we really looked into a lot of these and make sure they're segregated. So very important. And another question here, what is a double opt-in?
Yeah, so double opt-in is generally like somebody filled out a form online. That's how you got their name and their phone number, and that they might be interested in something. And then you would text them to confirm that the person receiving the text is the person that filled out the form. So it's basically requires them to respond back with like yes or agree or something to that effect to say that, yes, I really do want to communicate with you via text. So again, it was something that years and years ago, the industry best practices required when the opt-in came from an online mechanism rather than from your phone. So if you had texted in to them. They wouldn't require the double opt-in, but if you did it online to fill out a form, they did. That's no longer required. Again, it can be a risk mitigation tool, but it's certainly not required.
Awesome. All right. Those are the questions that we have. Feel free to put any questions in the next few minutes. Okay. Before we end the session, I want to let you know Bite Size offers a non-ATDS solutions, qualifies as a pure manual texting solution. So we went over, you can text more people in your database in a compliant way. So we're offering a 10% off the subscription for all the audience here. Bill, maybe you'll win sometime. So thank you so much for joining. And Nick, if anyone has any other questions, can they reach out to you?
Yeah, I'm happy to answer questions from any of the audience. My contact information was on one of the prior slides. Like I said, everything is fact specific. So you just want to make sure that you're taking all this information. It can help you issue spot, hopefully. It can help you kind of think about the things that are, the items that you need to check off your compliance list, but just make sure that you're thoroughly vetting everything. It is really important to make sure you do that before a campaign goes live, because the tiniest little details do matter. So happy to provide any type of help that I can.
Thank you, Nick. Thank you so much for your time and valuable advice. Really appreciate it.
Happy. Thanks for having me. Appreciate it.
Thank you, everyone.
All right.